Good afternoon, everybody.
Okay. Good afternoon, everyone. It's still some more people joining, but we'll start. My name is Nick Toms. I'm one of the employment practitioners at Doughty Street Chambers, as is Beth Grossman, who also deals with employment law. We basically have put this webinar together to deal with an issue that often you get asked about, which is the variation of the contracts of employment and how and when, and in particular to deal with the increasingly contentious issue of fire and rehire. If nothing else, hopefully what you'll get from this is all the sort of relevant sort of arguments and materials such as they are in one place, in one presentation. And we've got a few ideas as well. And of course, if anyone's got any questions at the end, we'll be happy to try and answer them. But without further ado, I'll hand over to Beth to kick off.
Good afternoon, everyone. So fire and rehire is an increasingly common tactic which is being used by employers. This is effectively when they want to change the terms and conditions of their workforce, normally to either reduce pay, reduce entitlement to overtime, or alter other beneficial conditions of employment, and then rehire that same workforce on worse terms than they had before. And this is a tactic which has become particularly widespread in the last year, either because employers perceive perhaps that they are under increased pressure, or because they perceive that their workforces might not be able to resist these tactics in the same way as they have done previously. According to a TUC survey, 1 in 10 workers have been told to reapply for their jobs on worse terms or face dismissal. And this is also a racial issue. 15% of Black and minority ethnic staff have faced this ultimatum, compared to 8% of white workers. There have been some highly publicised industrial disputes involving British Gas, British Airways, and Tesco in Scotland. It's particularly common in the retail and hospitality sectors. In fact, this topic is of such concern that it has been the subject of debates in the House of Commons in the last couple of months, and ACAS has published a paper on this very issue on the 8th of June. Now, what we are going to do in this webinar is explore the law in relation to this area to see what legal remedies might be available for staff when an employer wants to impose changes to their terms and conditions in this way. We'll begin by looking at varying the contract of employment. It remains trite, or it should hopefully be trite, and that a contract remains at the heart of the employment relationship. And in many ways, it is a fiction that traditional contract law applies to the law of employment as it does to any other type of contract. We all know, and we will come back to later in this webinar, the realities of the contractual relationship between employee and employer. But under traditional contract law, variation of a contract can only take place by consent of the parties, and normally according to forms of variation which may be specified within that contract itself. And therefore, if we were looking at this issue of hire and rehire through a strict contractual lens, in order to achieve a variation, an employer should be prepared to negotiate. However, some employers are either not willing to do this and or are not prepared to take no for an answer. And instead, what they seek to do is to impose their will on their employees. Now, an attempt to unilaterally vary an existing contract is difficult and will pose problems. The employee may simply reject the change and carry on working on previous terms, especially if there's no financial loss. one option for an employee is to seek a declaration in the High Court that the imposed changes are in breach of contract. And this has happened in a number of cases, including in 2015 in Sparks and the Department for Transport. Of course, High Court cases are civil actions with the usual risks of costs. And indeed, High Court actions are known to attract very substantial costs. So it would be difficult to see that this option would be attractive to many employees unless they were a group who had union funding or perhaps had the benefit of after the event insurance or some other form of legal expenses insurance. And if there are only a few employees involved, the employer can consider dismissing them for refusing to accept a business reorganisation. This is a point we'll come to again shortly. Where an employer attempts to unilaterally vary an existing contract and there is a financial loss to employees, they can work on under protest and bring a claim for unlawful deduction of wages. The case we've cited here of Burdeck, who's in Hertfordshire, concerned school dinner staff who challenged a unilateral pay cut. The argument was that the variation was such that it represented a termination. And the issue will often be whether there has been acceptance by conduct or acquiescence. This was again discussed in the case of Rigby and Ferodo Limited. If an employer unilaterally introduces new terms and conditions, they may try and resist any claim by contending that the employees have agreed, albeit not expressly, but by acquiescing, that is, by continuing to come to work. And the issues include what needs to be done to protect your existing contractual rights and how long must pass before you are taken to have agreed to the changes. And in Aberhole and Nottinghamshire, the Court of Appeal reviewed the existing case law on this issue. An inference of acceptance must be unequivocal. The lack of objection must be unreferable to acceptance. The employees must be given the benefit of any doubt. The protest at a collective level may be sufficient, especially where the terms are negotiated collectively. This means that the individual employee, especially if they are part of a union which is taking a firm stance, might not need to have said anything themselves. And this will, of course, be very important in circumstances where the individuals are not able to, because of the size or the structure of the organisation, make protests clear in any way other than not showing up to work, or where they fear personal ramifications. And acceptance might be based on the passage of time. There would be a difference between somebody who brought a complaint immediately and who made it clear that they were carrying on working only subject to that complaint being heard, against someone who turned up to work for a period of time before they raised any difficulties. Although, as that brief summary suggests, that question of acceptance and the length of the passage of time is usually fraught with difficulty. In deciding that there had not been acceptance, Underhill relied on several factors which were relevant to the specific case. The changes have been wholly disadvantageous to the employees themselves. This made it difficult for the employer to say that this was a case where they had accepted it because there had been some advantages mixed in with some disadvantages. Preventing redundancies or preventing some redundancies wasn't enough to say that this was a mixed case. And indeed, a mixed case scenario can be very important where, for example, an employer is proposing, say, to reduce bonuses but increase an hourly wage. The lack of individual objection has to be seen in the light of the fact that it had never been put to the individual employees that their agreement was needed, with the change being imposed. And the decision not to hold an industrial action ballot was not positive evidence of acquiescence. Ideally, though, what the employees should individually do is object positively and individually and carry on working so that there can be no doubt. And the outcome may depend on the nature of the change and whether it has an immediate effect. For example, a pay cut which is being proposed now, or something which is staggered or only taking effect some way into the future. A contract can be imposed. So on the subject of a unilateral variation and going back to it, the one option is to accept the changed contract as mitigation and bring the claim in unfair dismissal. And this was the position in Hogg and Dover College. Hogg was a teacher. He had fallen ill. He had been a department head on a full-time contract and was working reduced hours. The school at the end of the term informed him that his hours were going to be permanently reduced and they were going to remove his position as head of department. He responded immediately saying that he would work but only under protest and that he did not accept those changes. And the Employment Appeal Tribunal held that he could bring his unfair dismissal claim even though he was working for the same employer. And what the EAT said was, the question is not whether the relationship between the parties is seized. The question is not whether there was any contract between the parties. The question is whether the particular contract under which the employee was employed by the employer at the relevant time was terminated. That was the principle here. Was the particular contract terminated by the employer? And what we see the Employment Appeal Tribunal doing here is I think, doing two things at the same time. First of all, they are applying a fairly strict approach to the law of contract, and distinguishing the fact of a contractual relationship from the fact of a wider working relationship. That, of course, I would say, also ties into the realities of the employment situation, where it might not be possible for a party to terminate or to protest a termination by leaving. Another option which an employee might have is to resign and bring a claim for constructive or unfair dismissal. This would not be attractive for most employees because they would have a mortgage or rent to pay, other bills, family members to support. The change would need to be sufficient to amount to a fundamental breach of the contract. And as most employment lawyers have a good experience of, this can be a very difficult matter to prove, although in these circumstances, very far from impossible and very possible that it could be if the facts aligned properly. However, the difficulty in bringing a claim in constructive dismissal is that even if the employee is found to have been constructively dismissed, the dismissal could nevertheless be considered fair, particularly if the employer is relying on some other substantial reason. And this is a point that we will come to over the next few slides. In Alcan and Yates, the employer sent a notice to all employees requiring them to change to a new continuous pattern of shift work, remove their right to overtime, and made other adverse changes. The employees responded saying that this was a fundamental breach, tantamount to a dismissal, and that they were working under protest. This was not a case in which they relied on constructive dismissal, but it goes to this sort of issue. Alcan, the employer, appealed on the basis that the changes were not a termination. The Employment Appeal Tribunal upheld the decision that it was. The departure from the original contract could either be a termination of that contract or simply a breach of that contract, which did not amount to a termination. The question is a matter of degree and an issue of fact for the tribunal. So although it worked out well for the employees in this specific case, that question of a matter of degree and an issue of fact, whilst it does give employees quite a bit of leeway, at the same time creates a considerable degree of uncertainty. Now, in many cases, what an employer will want to do, what an employer is trying to do is reorganize their business. And very often they will have consulted with employees. They won't want, in fact, to be dismissing employees. They simply want, or perhaps perceive that they need, to change the terms for such a business reorganisation. Now, on the whole, this area favours the employers, provided that they can demonstrate that there was a business reorganisation that has some objective validity to it. Although the case law does also suggest that the issues for the employer will need to be balanced against the effect of the employee. But the cases we've cited, Hollister, Bowater, Grenauer, all these cases lean heavily in favour of the management's right to manage the business as they see fit. Although it is wrong to say that employees have no rights in these situations, the extent of a consultation is a factor that the tribunal would need to consider. The employee must demonstrate at least some advantages to the business, and it is material whether the business is making a profit or a loss. A business which is making a loss will find it much easier to rely on a business reorganisation than a business which is simply complaining that it is not making enough of a profit. In Copsey and WWB Devon, this concerned a dismissal due to religious beliefs when an employee refused to accept a change to his contractual hours. The Court of Appeal held that the dismissal was fair because the employer had compelling business reasons for the change, and they'd done all they could to accommodate the employee's wishes. In Garside and Laycock against Booth, the tribunal considered that it must focus on the reasoning and the reasonableness of the employer and what it is reasonable or unreasonable for the employee to do. The employee's subjective view of what is reasonable may be taken into account, but the decision does not depend on it. And the tribunal must determine the question under section 98.4a of the Employment Rights Act in accordance with equity. And the relevant issue here was the question of a pay cut which was imposed across the workforce and whether that was reasonable or on behalf of the employer, and what would have been reasonable or unreasonable for the employees to do by way of accepting that pay cut or not. And in that case, because it excluded the managers and it went to effectively the shop floor staff alone, then it was considered reasonable for the employees to reject that. And so it is possible to go behind some other substantial reason as a reason for a fair dismissal. Moving on now, I shall hand over to Nick.
What Beth has sort of gone through so far, sort of some more well-known case law and issues that arise in business reorganisation stroke variation of contract cases. I think just to summarise, I mean, what it shows is that in many ways, there's a lot in favour of the employer in these situations. Some of those more recent cases, like Garside, have indicated, perhaps more recently, at least some acceptance that the employee's rights have to be considered to some extent, but not a great deal. But even despite the fact that the law quite heavily favours employers, the fact is that they are still sometimes not satisfied, and really the use of the fire and rehire tactic is something which, of course, gives them a further option. And it's something which we've seen being used increasingly frequently during the course of the COVID pandemic, as companies claim, and sometimes no doubt with justification, that they're in severe difficulty as a result of a pandemic, collapse in their market, etc. And they need to reduce the pay, stroke, terms and conditions of their workforce, and so on, and it's become increasingly prevalent over the course of the last 18 or so months. It's not a popular tactic for the public. A surveyation poll for the GMB found that 76% of those surveyed opposed fire and rehire, and that included 71% of Tory voters. Pointed out there, even Boris Johnson has said it's unacceptable for people to be treated in this way, although of course his government has done nothing about it, and in reality he's probably saying this because he wants to try and pretend he cares about the people in the Northern and West Midlands and other seats the government won in 2019, and show that they are on the side of the employee, when in reality he probably supports employers being able to do whatever they want. And I say, whilst it is unpopular, it is being increasingly used. Do you want to mind moving on, Beth, for the next slide? So what are the options for an employee faced with an employer behaving in this way? Well, there is, of course, a dismissal. There's no doubt there's a dismissal. You've been dismissed, although you have the opportunity to go back to work the next day on the inferior terms and conditions. That, of course, won't change the fact that you have been dismissed. So you can bring, given there's dismissal, a claim for unfair dismissal. But as Beth has really gone through just now, this is, precisely back to some other substantial reason where the law largely favours employers. I've given you one case there, Forshaw and Archcraft, 2005, where the EAT held overturning the Employment Tribunal that based on the finding of the Employment Tribunal that the restraints of trade clause was far wider and was necessary to protect the business, to dismiss people in those circumstances and rehire them, they found was an unfair dismissal. But the reality is that many of these cases, as long as the employer can show some reasonable good business reason for the decision, there's some evidence. Tribunals tend not to probe too deeply in the same way they don't really probe too deeply in the event of redundancies being necessary. So as long as there's been some consultation, as long as there's evidence of a need for the business to make these changes, then that will be sufficient for the employer to succeed, and the claim will fail. I mean, certainly where people, I've experienced in the past where there've been, councils have done this. I mean, I remember Southwark Council doing this quite a few years ago. You tend to find that most people, of course, will accept the rehire because they've got no choice. They can't just not have a job the next day, so they have to accept it, whether they like it or not. And that's a factor then that the tribunal will use and say, well, the vast majority of the people accepted the change, and therefore it shows that it's reasonable, etc., etc. Of course, it shows absolutely nothing of the sort. It shows that those people have got no choice but to go to work and earn their living, and they can't just walk away in those circumstances. But nevertheless, and as a consequence, the law favours employers, and these claims are often difficult. Do you want next slide? Yeah, I've given you another example there. That's a case of Slade and others versus T&T, where the EAT upheld the finding of a fair dismissal, where the employer had initially, in the course of negotiations, made an offer to buy out a bonus scheme in exchange for an agreement, or to offer a bonus scheme in exchange for an agreement to change terms and conditions. It was rejected, and then they were dismissed and re-engaged on the same terms without any bonus or buyout of bonus. And basically, the EAT upheld the finding of the Employment Tribunal that the dismissal was for some other substantial reason and was fair, within the range of reasonableness for the employer to do that. So you can see that case, I think, does underline the difficulties in these in these claims. Should we move on to? Another option, of course, similar to the one, therefore I won't dwell on it at any great length, is you accept re-engagement because you've got no choice. You've got to have a job, but you nevertheless say that, well, I'm accepting it as mitigation of loss. I have been dismissed, and I'm going to nevertheless bring a claim for unfair dismissal, relying on the principles in Hogg, Alcan extrusions, etc. And if depends on what's happened, of course, each case will depend on its own facts. But if the employer has acted wholly unilaterally without consultation, just simply imposed a change, dismissal could well be found to be unfair, and a possible measure of damages would be the net loss to employees under the new terms. But I suspect in many cases, even if you are able to bring an unfair dismissal claim, it'll be back to some other substantial reason, business reorganisation, and the difficulties which we have already outlined. A further quite interesting option is where you've got more than 20 employees affected, is a possible claim for failure to consult in relation to collective redundancies under sections 188 and 189 of the Trade Union Labour Relations Consolidation Act 1992. How can you do this? Well, the reason you can do this is that the term redundancy in the context of section 188 is not limited in the same way as the term in section 139, which deals with the issue around your rights to a redundancy payment. Section 139, sorry, of the Employment Rights Act 1996. Instead, section 188 relies on a definition of redundancy drawn from the wider European law definition, which basically defines a redundancy as any dismissal not related to the individual employee. And that is now found in section 195 of TULRA. And so relying on that, you can bring a claim, that wider definition of redundancy. So basically, clearly, if you are fired and if you're hired and fired and rehired, you clearly have that is going to be within the definition of a redundancy in these circumstances. And if the employer hasn't gone through the various steps to consult as they're required to do in section 188, then you could bring a claim for a protective award under section 189. And of course, it is not going to be obviously a full replacement or substitute for your loss of whatever terms and conditions you've now lost as an employee, but the remedy is quite valuable, up to 90 days pay. And of course, you may be aware that the purpose of the award is punitive. That's the GMB and Susie Raiden case 2004. And the starting point should be at the higher end, with the employer being the one who has to argue it down, given the purpose of the award and in these cases. Move on. And I've set out there the sort of thing that should be consulted on. It's quite detailed. I think there's a little bit left in there. It shouldn't be left in there anyway. I'll note as well that consultation must be genuine and meaningful, while the proposals are still at a formative stage. That's the Middlesbrough Borough Council and TNG Unison, where it says it's insufficient to consult over ways of reducing numbers to be made redundant. The employer had to consult on ways of avoiding the dismissals altogether. In Junk and Kunal, you've got there the helpful European Court of Justice decision that consultation must begin before any notice of dismissal is given, not just before the notice ends. So all of those potentially apply to the unwary employer who embarks on the fire and rehire tactic involving more than 20 members of their organisation. If we move on to the next slide. I've also put in here, just out of interest, but the definition of redundancy in the context of the directive in the European Union was considered in these cases, Polish cases, involving Polish hospitals who were reorganizing in different ways. And interestingly, the European Court of Justice there held that the consultation rights, Articles 1 and 2 of the directive, apply where the employer announces unilateral changes, leaving it to the employees to decide whether or not to accept them, but with an implication that any who do not will have their contracts terminated. So note there doesn't actually have to be a proposal to fire and rehire. It's sufficient, but that can be implied from the way in which the proposal is being advanced. So consequently, you can see that a contractual change in and of itself is not a redundancy, but if it contains the possibility of dismissal, it becomes so, thereby bringing in the rights to the statutory consultation, of course, subject to more than 20 people at least being in the frame for this, in inverted commas, redundancy. And in fact, in the second of these cases, the ECJ said that the employer should have reasonably expected that some employees would not accept the change to their conditions of employment, and as a result, their employment would be terminated, and that was sufficient to engage the consultation requirement. So it does seem that one option, certainly in these circumstances, depending on how the employer has conducted themselves, is to carefully look at, have they consulted at all? Have they consulted meaningfully? Or is it, is it really just a complete sham? Is there any evidence of that? And have they satisfied the different requirements of consultation in section 188? And if not, should a claim be brought for a protective award under section 189? That's another option. So, Beth, don't move on. Right, other possible options. Well, in some ways, the law on the nature of the employment relationship is all over the place. Is it contract? Is it a contract which should be, considered carefully and in the same way any other contract is considered? Or really, are we looking at in the employment arena, really not so much a contractual relationship as a relationship based on the status of the employer stroke employee relationship? And you can see already the sort of issues we've been looking at in some of the cases. In the Hogg and Dover College case, for example, there the courts, or the Employment Appeal Tribunal, there very much looked at it as Beth said, quite strictly contractual point of view. However, some more recent authorities, in particular, relating to the employment status at all, have been prepared and gone and looked at beyond the traditional form of the contract. And the starting point and perhaps the best of these decisions is the Auto, Cleanse and Belcher decision, which looks at the relative bargaining power of the parties, which they say should be taken into account, and that you need to look beyond the circumstances of the written contract, and instead look at the substance of a relationship rather and what it's based on, and rather than the form. And certainly there's another case, Kalchak, which Mr. Justice Elias, President of the Employment Appeal Tribunal, I think as he then was, also said that one of the issues with the employment status arguments in particular is that you will have armies of lawyers beavering away, writing up completely fictional contracts, with all sorts of bizarre rights of substitution, when in reality, this is this person's job. They're going to work, and the idea they can get their next door neighbour to go in and do it for them, of course, is nonsense. But nevertheless, this will be cooked up with the purpose and aim of trying to avoid employment status or worker status for the employees. I've also, a separate reference to the status and the relationship of employer-employee, also found in, for example, the Unison case. This was the one which basically challenged the employment tribunal fee system successfully. And there's a quote there: relationships between employers and employees are generally characterized by an imbalance of economic power, recognizing the vulnerability of employers to exploitation, discrimination, other undesirable practices, and the social problems that can result. Parliament has long intervened in those relationships so as to confer statutory rights on employees rather than leaving their rights to be determined by freedom of contract. Certainly, that's perhaps not as helpful as the Belcher case, but again, it's all pointing in a direction that if it's not really right in these circumstances to rely purely on contracts. So if we just move on. So possible arguments, I just want to come on to possible other arguments and options. If it's not realistic necessarily to base the employment on traditional contractual principles, can it be contended in these cases that the relationship of status and the vulnerability of employees means that the traditional contractual principles should not necessarily apply not only to, for example, employment status, where you look beyond what is actually on paper in the written contract in certain circumstances and what is actually happening on the ground to show what has actually been agreed. Can we also make that same argument in relation to the provision which the employer is relying on of the contract in the fire and rehire instances, which is the notice provision in the contract? But if you of course strictly apply contract law, then there's nothing wrong with an employer saying, well, there's a notice provision in the contract. I'm exercising it to fire you, but of course I'm offering you the chance to do exactly the same job, but on 10% less pay the following day. So can we, and is it going to be possible to make the same arguments? I note as well, not only in the auto cleanse, but in Abrahall, again, the courts in particular circumstances have disapplied traditional contract law, taking into account the nature of the employment relationship. And in Abrahall, for example, in that case, in the judgment of Mr. Justice Elias, or Lord Justice Elias, said that it, of course, in one sense, in terms of acquiescence, then trite contract law is that where someone is in breach, you don't have to notify them of a breach, and you've got 6 years, in fact, to bring your claim. That's the traditional contract law approach. But so that is actually not really realistic in the employment context to rely on that very strict interpretation of contract law. And having made that observation, he said he did go on to then to say, of course, which wouldn't be helpful in a case based on status. It's always open to the employer to terminate the contract. And so, in a variety of circumstances, there have been arguments that the strict rules of contract have not been applied, given that this is a further example of clearly the dominant party, the employer, exploiting their dominant position in order basically to do something you can't normally do in contract law, which is to unilaterally change the terms of the agreement. Then is that something which could be used in an appropriate case to try and resist fire and rehire, a case where a particularly dreadful example of fire and rehire by an employer has been used. Another possibility might be, in a similar vein, would be to contend that in fact that what is really happening is a sham, because there's absolutely no intention whatsoever of terminating the employment relationship. The employee, in some of the older cases like Hollister, then that was in fact exactly what the employer was doing. The employer was firing the employee in order to because they wouldn't accept a change in their terms and conditions. And so there, there clearly was an intention to terminate the employment relationship. But in the fire and rehire cases, then there's not. So if you look at British Gas, they can't do without all their gas workers. They need them to run their business. So there's no intention whatsoever to get rid of them. Their intention is simply to cut their terms and conditions. And so the whole thing is simply a legal maneuver to avoid the rights of their employees from their contracts of employment. And certainly in AutoCleanse, the term sham was given a wider meaning than in traditional contract law. And the point was made there that you are looking at substance rather than form. I'd have to say that against this, the interpretation of AutoCleanse in the subsequent Uber decision earlier this year is not so helpful, because they said that the basis of the interpretation of the basis of the approach in AutoCleanse, and the reason why it was appropriate to disapply effectively traditional contract law in this situation is you can't contract out of your statutory rights under the legislation. Now that is, which of course is right, you can't, in either the Equality Act, the Employment Rights Act, you can't contract out, and therefore effectively these contracts of these terms, which are basically fictitious, the substitution clauses, etc., all an attempt effectively to get someone to agree contractually to certain circumstances, which means they can't be an employee or a worker. And if in Uber, it was said that the explanation for that approach in AutoCleanse was that it's a statutory right you can't contract out of. That's obviously not helpful in terms of saying, but why not disapply the contractual minimum notice, the contractual notice period. However, that was not the rationale used by Lord Clark in AutoCleanse himself. He didn't say that. And so I don't think that necessarily means that the argument would be hopeless, although that clearly would be a difficulty in arguing this point. As I said, in reality, that for allowing variations in this way is simply allowing them where to do something which simply is not ordinarily possible in contract law, and in circumstances where they're taking advantage of another party's weakness and vulnerability. It seems to me it's an argument that is worth exploring. However, of course, the reality is that there may be no legal means ultimately of preventing employers acting in this way in our society, where the courts, by and large, are biased and firmly in favour of employees and employers and employers having the dominant upper hand. And it may be that ultimately will mean that it's not possible to legally resist this sort of tactic by employers. Move on to the. Although this is, of course, a legal seminar looking at the law, the fact is that these may be industrial matters and not matters which can be litigated. The law is not the best way often of dealing with industrial matters. And is not necessarily a substitute for more traditional ways of resisting employers acting in this way, such as mounting campaigns, public campaigns to try and sway public opinion and put pressure on governments to make political changes. Of course, as happened in the British Gas case, industrial action, strike action, action short of strike action, may be options that need to be considered by employers, and indeed their advisors may ultimately say that is all, that is what you'll need to do. And of course that will depend on things such as the strength of the union, the resolve of the employees to take action to prevent whatever is happening to them from happening. And we know that's easier in some industries than others. And the guards on Southern Rail have been battling away for years, taking strike action after strike action for years, resisting one person only operation of trains by that railway operator. Other industries may be more difficult to get that sort of thing off the ground. And ultimately, of course, it may be that this is something which trade unions and claimant employment lawyers will need to put on the political agenda. I've mentioned there the very recent ACAS report, Dismissal and Re-engagement, Fire and Rehire, a fact-finding exercise, which covers some of the sort of options for legal reform, which I won't go into here, but is worth looking at in terms of what sorts of things can be campaigned on and raised in terms of reforming and changing the law to prevent a practice which, you know, in this country is allowed, in other countries already is prohibited. Spain, Republic of Ireland, is something you can't do in these countries. Beth, is there anything more you want to add? I think that's the last slide. Or is it any question time?
I'd put myself on mute. That's the end of our slides now. Nothing for me to add, but we have a question, which is, or a point rather, from Julian Gallimore. What happens in the UK will soon be replicated in Australia. Corporations run most companies. So the question is, back in the 1990s, unions would do deals for money for retiring staff to sign away historical workers' employment rights. And how do we stop this? It has been delicate at the TUC in London.
I think he's saying there he's a delegate to the London.
A delegate. I misread that.
Regional committee from the T&G union, which is Unite, of course, these days. I don't know if we can really help him with there. I mean, you know, what unions do is obviously a matter for the policy and decision makers of the union, and if they do things that members don't like, then they've obviously got to try and organise and raise those issues within their unions. I don't think we can really probably say much more to assist on that particular point. I don't know if there's any other questions.
No other questions. Would anybody like to ask any other questions?
Okay, well, I think that's, well, thank you all for attending, and I hope you've got something out of this webinar.
Yes, and if you have any questions afterwards, do feel free to get in touch with us. Richard is able to send the slides around, and we'd be delighted to take this up with you further if you were interested.